Hello. Today we're going to be talking about Chapter 10 in our book, Get Your Michigan Driver's License Back, that I wrote with Matthew Zick, telling you basically everything you need to know about the process of getting your license back so that you are prepared for the hearing and can put your best foot forward. Chapter 10 says driver's license restorations are subject to Murphy's Law. Murphy's Law, as I'm sure you know, is that anything that can go wrong will go wrong. So it's important to anticipate potential problems both at the hearing and even after you get your license so that you don't wind up defeating yourself at some point and having to start the process all over again, or just giving up in defeat because of something that really could have been prevented or wasn't even your fault. The first thing that we want to talk about is the issue of a secondary diagnosis. On your evaluation now, it asks for all diagnoses that have anything to do with substance abuse or mental health. The presumption is that if you have a mental health diagnosis that, for example, if you suffer from depression, that your depression may at some point in time trigger a relapse into active addiction. So they want to know if you have, for example, bipolar disorder, and if you're getting treated for that, and what your counselor says. There are forms called a DI-4P, or even just a letter from your treating psychiatrist or psychologist or social worker that says that you are handling your depression, that it's under control, and that it won't cause you to relapse. But also on the evaluation itself, you have to have a diagnosis for every drug that you've taken. So for example, if your main drug of choice was alcohol, but you smoked weed when it was being passed around at a party, then you would have a primary diagnosis of alcohol dependence and a secondary diagnosis of cannabis abuse. Even though the DSM-5 has somewhat changed the diagnosis procedure, I prefer to go with the DSM-4 diagnoses because they make a clear distinction between dependency and abuse. And I think that's more helpful to hearing officers, and it is important to make that distinction between whether or not you were just abusing a substance or whether or not you were psychologically and or physically dependent on it. So we want to have the diagnosis for your primary drug, alcohol dependence, your secondary drug, cannabis abuse, and if there's a diagnosis for, say, minor depression, not major depression, but just say something we call dysthymia, that would be an additional diagnosis. And we would have to make sure that all of those conditions are in remission, and we want to make that real clear to the hearing officer, or you would not be eligible for your license. If people make the mistake of leaving a drug off of the evaluation and it comes out at the hearing, you will be denied. It's very important that you're consistent all the way through the process. Any inconsistencies are grounds for denial of your license. And this is particularly important if there's any record of any offenses. If you deny that you used any other substances, but you have a conviction for cocaine possession, it's very difficult to make the case that it was somebody else's cocaine. Sometimes clients will try to do that. It's not usually something the hearing officers are going to buy. They're pretty sophisticated people. It's pretty hard to make that case. Another issue that comes up is your status, whether or not you're on probation or parole. If you are, the hearing officers tend to look askance at that. They don't really consider you to be sober on your own. They like to see how you're doing without any kind of supervision by the state. So a lot of times that will be an issue. Sometimes they might award you a license even though you may still be on probation. And I think the exception to the rule probably are for people that may be in drug court or sobriety court. They may get a license from the court where they're on sobriety court. May award them a temporary license with a breathalyzer during the time that they're actually in sobriety court. We'll talk about that sometime, because it can be a good deal if you are a person whose license is going to be pulled. This is a way of getting it back on a trial basis. But you still will have to go before a hearing officer at some point, and he will look at your performance while you're in sobriety court, but he will probably look at you a little closer than he might look at somebody else who has had to go for at least a year without a license before he could even apply. The drug test can be a problem area also. I have found sometimes people want to do their drug tests somewhere else. I do them in my office and I send them out to MedTox lab. They're done under the forensic protocol, and I know that the results I get are good. I know that they're going to pass muster, and I know that the hearing officers are going to be satisfied with them. Not every drug screen passes muster. Sometimes if you walk into a lab and order a drug test, typically they will not give you integrity variables. Integrity variables are things like creatinine and specific gravity that measure whether or not your urine is concentrated enough to test, first of all, and whether or not it's been adulterated in any way. So it's important that you have those integrity variables because the state now requires it. If you give them less than they require, you're probably not going to be successful. Sometimes people think they can slide through this. There is no easier or softer way. You have to do everything they require, and it's a good rule of thumb to try to do more than is required. My tests, for example, have 3 integrity variables instead of 2. So it's better to do more. It's not a good idea to do less, especially if you're on the borderline. I recently had a client who had a creatinine level of 19.8, and even though that's only 0.2% away from what is considered a valid creatinine level at 20, I asked the client to come back in and retest, because if he's on the borderline or if they're uncertain about whether or not to give him a license, that 0.2 will make a difference, because technically he's below what is required. This is really a difficult process. The standard of proof is clear and convincing evidence. The burden of proof is on you. You want to make sure that you do everything you possibly can to be successful. Another problem is once you're awarded a restricted license with a breathalyzer, at some point in time you're almost certain to blow positive. It doesn't matter that you haven't been drinking. You might have eaten pizza and the yeast might actually trigger a positive reading on the breathalyzer. So you need to be prepared for that. And 2 things that you need to do are, 1, you need to keep water in your car or on your person so that you can rinse your mouth out before you blow again. Okay? And the second thing is, if it continues to register positive, you need to get a clean reading as soon as possible. It might be equipment malfunction, but you need to go to the police station and ask them to breathalyze you so that you have some proof of the fact that you have, in fact, not had anything to drink. Another thing that sometimes comes up is that clients will sometimes refuse a breathalyzer. You may intuitively think that this is giving evidence against yourself and you're not required to give evidence against yourself. However, the state doesn't see it that way. They see driving as a privilege, and they have a law called the Implied Consent Law, which is that if you are going to drive on Michigan streets, then you are implying that you give consent for them to test you for whether or not you are positive for alcohol or other substances at any time. So if you refuse a breathalyzer, you will automatically have your license pulled for a year. Now, with an attorney's representation, you may be able to go down to the to circuit court and get a restricted license issued by circuit court if they deem you to be a good risk. However, It's a lot of aggravation. You will still have 6 points on your record. You'll still have to pay driver responsibilities fees if they apply. You will be without a license for a certain period of time until you can get before the circuit court, and you will need to hire a lawyer, which is another expense in addition to the cost of defending yourself in court. So it's a good idea not to test the law here and to breathalyze if you in fact get pulled over for DUI. If it's your first offense, in most cases they will restrict your license for 90 days and you'll pay some fines and some court costs, and if you don't have any more problems you'll be okay. If it's your second offense, then they are going to take your license and you're going to have to go through this process. But it's best to cooperate. If you don't cooperate, it's going to be a lot more problem. Finally, when I finish the evaluation, I always tell my clients, this is the gospel according to you. Anything else is heresy. It really is important that you know what's in the evaluation, and that what's in the evaluation matches up with what you put on Form 257 and what your people say in support of you in their letters, which should be signed, dated, notarized, have your last drink date and the contact information for the person on them. And all of this has to line up with what you say at the hearing. If all of your evidence is consistent, but at the hearing you don't remember something, or you try to deny something such as use of marijuana when you admitted it at the hearing or on your evaluation, then you're going to be denied as being not trustworthy. What you say is not going to be deemed to be consistent, honest, and trustworthy. And it's very important that they're confident in you, that you are a man of your word or a woman of your word, and that you can be trusted with a driver's license and trusted not to drink and drive. Remember that these people are entrusted with keeping the roads safe. This is a very serious job, and they take it seriously, and they want to do a good job. So if you are qualified, they want to put you back on the road. If you're not, then they're not going to do that. They're not going to endanger the lives of people that are out there obeying the law by putting you on the road if they think you're going to drink. So it's important that you anticipate the potential problems. If you do so, then hopefully you'll get a restricted license, and if you drive safely for a year without any incidents that you can't clear, you can go back and get a full license, and you should have no more problems as long as you don't drink and drive. Thank you.